Our third case this morning is 2019-56, the City of Brookpark versus Joseph G. Rodojev. Mr. Miley.
Chief Justice O'Connor, and may it please the court, Andrew Miley for the appellant. With me on brief is Ron Miley. We're asking you to reverse the 8th District. I will first address the conflict issue and then address the supposed failure to object in this case. The conflict in this case is over whether in a governmental prosecution that totally hinges upon the use of technology, whether the government must prove that the technology is reliable or not.
But don't government prosecutions depend on technology all the time without the government having to prove it's reliable?
Yes. Well, I don't know that that happens all the time when the government does not have to prove that that's not reliable.
You have a copy of a document. The government doesn't have to prove the copy machine works. It doesn't have to introduce evidence on that technology. I
don't know any cases where whether a coffee machine works goes directly to the heart of the offense.
A copy machine, a piece of evidence. You don't have to bring in the underlying scientific principles of a copy machine.
I think that scenario is easily distinguishable here because because the evidence is the whole offense. The speed device goes towards the speed, which is the essential gist, the element of the whole offense.
Well, what if it was a stopwatch? What if it was an offense that's a stopwatch was critical evidence, or a clock, what time it was?
Again, that would not go directly to the element of the case. I don't know what that situation would be.
It could be. You could have a murder case where what time someone was in a certain place, establish an alibi. Why wouldn't, under your scenario, why wouldn't someone have to come in and explain how a clock worked?
Well, this is patented technology at issue in this case, Your Honor.
Well,
the state says.
So that's the distinction, whether or not it's patented?
Absolutely. We pointed out in our reply brief that this is patented technology, and the manufacturer.
So any patented technology, that should be the rules. Yes, you have to explain the scientific basis for it.
When that goes straight to the element of the offense and is, in fact, the whole offense. I think this is a unique situation in that regard, totally different than the stopwatch or a copy machine examples that you're giving. The manufacturer of the LTI 2120 device in their own marketing materials, which we pointed out in our reply brief, says that this machine uses sophisticated algorithms. In the amicus briefs in this case, and in Brookpark's brief, they tried to make a big deal out of this is actually simple technology. This is not simple technology. The United States Patent and Trademark Office issued a patent in this case. But even if this was simple technology, I'm at a loss to understand why that would be a basis to do away with judicial notice. Evidence Rule 201 are for facts that could be undisputed. So the more that Brookpark or the amicus parties argue in this case that, well, this is really undisputable technology, I think that argument proves too much. Just use Evidence Rule 201 then, Your Honors. If that's not the case, why would we have Evidence Rule 201? We're not asking a lot. We're asking that they do one of two things: prove reliability through either expert testimony or through judicial notice. And judicial notice itself can be proven in one of three ways. The trial court can rely upon expert testimony that the court heard in a prior case. The trial court can cite to a decision finding the device reliable in another case from that court, or from a court of appeals decision that affirmed the reliability of the device, as long as it's from an appellate court situated within the district of the trial court at issue.
Counsel, what about your client's failure to object to the introduction of the evidence in the presentation?
There's no failure to object. There's a failure of proof here. This is an adversarial system. The adversarial process
Wait a minute, did your client object to the officer's reliance on the device?
Yes, but what we take issue with is the Brookpark's characterization of a failure. That presumes that he should have objected. This is a failure of proof. If I was trying this case, and I've tried a few cases, and the prosecutor failed to introduce evidence of reliability, I wouldn't say, objection. He's not doing his job right. He needs to do X, Y, and Z and provide the prosecutor a roadmap on how to better prove his case. I would, at the end of the case, say, you have to discharge. There's no evidence of reliability. And so there's in fact no objection in this case, but that's not a failure on the defendant's part. The failure here is a failure of proof.
Was there a
on the state's
move to
part.
dismiss after the conclusion of the state's case?
No, Your Honor, but they're in our briefs.
What about at the end of the trial?
No, but that is preserved by his not guilty plea. This court has repeatedly said, and the United States Supreme Court has repeatedly said, that a not guilty plea by a defendant in any criminal case, in a speeding case, is a criminal case. You can go to jail in Ohio in certain speeding cases. That's why this case is so important. There's a liberty interest at stake here. When you plead not guilty to an offense, you have an absolute due process right to put the state to its burden on each and every element of the case. And back to Justice DeWine's questions, either. I appreciate what his questioning is geared toward, but this is a unique circumstance. The entire case rests upon proving the speed. That is done by statute using some kind of device.
Counsel, can you not think of any other situations like that?
Well, there are DUI
About,
cases.
What about child pornography? Relies solely on images. Do we have to talk about the technology of a camera and how those images are produced?
That those are hot button issues in many cases, because with spoofing technology and nowadays, I've spent a lot of time and money with experts getting into digital technology, and whether it's an actual image or whether it's a computer CGI generated image, whether it was planted on someone's phone by another device.
But is that different from having to take some sort of notice about how it was produced in terms of a camera?
I think the notice here has to be, or the reliability here has to, these are tools of prosecutors. A copy machine, a camera, those aren't tools geared towards prosecution. That is the only purpose of a laser device. The state basically has a monopoly on these devices. And what attracted me to this case really honestly wasn't so much a laser device versus radar device. It's really the law of unintended consequences. Because if the Supreme Court of Ohio, in this case, judicially whittles away at reliability issues, there's going to have a host of unintended consequences down the road, where new technologies may come out and the government comes and says, well, in State v. Rodojev, we don't have to prove expert testimony anymore or take judicial notice.
Counsel, is there a difference between proving or demonstrating accuracy and through calibration records and testimony from the officers in charge of those devices and what you're arguing here?
Well, there's three things, I think, if I try to answer this in kind of a broader context. The officer needs to be trained. The device needs to be calibrated. But those things only matter if the device, the manufacturer's device, is reliable.
Well, the appellate court found that expert testimony on the scientific principles involved in speed detection could no longer be required for modern laser or radar measuring devices that work on the same principles deemed scientifically established in Farrell over 60 years ago. That's from the appellate decision.
Yes.
So that suggests to me the only thing that can be challenged legitimately is calibration and expertise or training of the officer.
Okay, then we can take judicial notice. What's the harm? The state gets the benefit of Evidence Rule 201. Therefore, they should have the burden of fulfilling and taking advantage of that rule. That's why what we're asking. We're
What would
not
that
asking for
require
much.
them to do? They're taking advantage of that rule.
To say something like, Your Honor, I ask, so the officer would testify to his training, his or her training. The officer or another witness would testify to the calibration, and that evidence would come in. And then the ultimate thing, to answer your question, is the prosecutor could either elicit expert testimony, but if they want to take judicial notice, they would say, Your Honor, we ask you to take judicial notice that the 2020 laser device is reliable. This court in State v. Smith or State v. Doe found that it was reliable, and that decision was affirmed by the 8th District, for example. And then at that point is when the defendant may or may not object. That's when an objection would be ripe. There was no really justiciable objection because Evidence Rule 201 says that judicial notice can be taken at any time in the proceeding. So usually it would be at the end, in a situation like this, the testimony would come in, and then it would be at the end of the officer's testimony, and the officer doesn't even testify as to judicial notice.
Can it be raised on appeal, judicial notice?
It can be raised on, there are cases that say judicial notice can be raised on appeal. I think, is your question, can judicial notice be taken on appeal? It can be taken on appeal, but I've never really seen it in a context like this where you're taking judicial notice of a fact that determines that goes straight to the heart of the prosecution.
Can a municipal court that handles thousands and thousands of these types of cases a year just put on a standing order regarding the technology that is used?
No, because each defendant has a right in their own case to make an objection if they choose to. Basically, Mr. Rodojev was denied that here. So until the proffer is made and there's nothing for the defendant to do. So I think I've answered your question about the mechanics of how it works. There are other instances where reliability is at issue would be in the OVI, for example. And this, it's not in the briefs, but it occurred to me after talking here in the ILG case out of this court, I believe from 2014, ILG. The state contended that the Intoxilizer 8000 was inherently reliable, and the defendants are not allowed to get discovery as to reliability. This court rejected the state's arguments in that case and sided with ILG and said that he was entitled to the discovery that went to reliability. And then after the ILG decision, basically, for the most part in Ohio stopped using intoxilizers.
That was a discovery issue. That wasn't at trial, what are you going to present issue.
Right. This is even worse, though, because we had the trial and they did not present the issue. No reliability evidence was presented in this case, which then is not
Well, there was no challenge to the reliability of the laser prior to the hearing, like there was with the OVI in the ILG case, where they were questioning the actual scientific principles of the measurement device.
There's no requirement that in the speeding ticket, unlike in the OVI context, there's no requirement that it not be raised. The only requirement of the defendant to preserve this issue is to plead not guilty. That puts the state on notice that, okay, I need to get my evidence in and present sufficient evidence, at least sufficient evidence on every potential element in this case. Here the element is, was he exceeding the posted speed limit or not? That's the whole case right there. There's no evidence of reliability. So again, this is patented technology. The marking material says we use sophisticated algorithms. In the government's briefs, they said, oh, this is basic technology. I know that they waived their oral argument today, but I doubt any lawyer in Ohio could get up before this tribunal and actually really explain how any particular device works. I'm not talking about how laser tech. Back in the Farrow case, they were talking about radar technology generally. First of all, this is not a radar case. This is a laser case. The rules of evidence, the judicial notice rule was not in place at the time of Farrow. But what we're asking this court to do is say that yes, the technology has to be shown reliable, but it's the device that has to be shown to be reliable. What the prosecutor's briefs have
The
said.
actual device used, that's what you're talking
That
about?
model,
Not
yes.
the general, okay, no, the actual one used, not
Yes.
the 100 different devices, this actual one, which goes to calibration and training of the operator.
No, the model has to be shown to be generally reliable, Your Honor. The model, this is the LTI 2020 model, I believe they called it. What the prosecutor amicus briefs are saying, what they're asking you to hold in this case is to say that all laser devices are reliable, and if new devices come out in the future, we don't have to show their reliability in any way, either through expert testimony or through judicial notice. And that's what I'm talking about, what makes this case so important. The court below said, oh, we're in a time of great technology. Technology is outpacing the law. This would be a terrible time to lessen the reliability requirements in criminal cases because of the advent and the proliferation of technology is precisely why we're asking you to reverse in this case. If there's no other, Chief, I think you have a question.
No, I don't have a question, I'm just telling you your time's up.
Thank you, Your Honor. Thank you. Please reverse. Thank you.
All right, we'll take the matter under advisement. You'll be notified of our decision. Marshal, will you call a recess?